Objection.
Mr President.
Leader of the Opposition.
Mr President, I lead for the Opposition on the Victims' Right and Support Amendment Statutory Review Bill. The Opposition does not oppose the bill, given that it's largely a technical bill, making the kind of comparatively minor amendments we would expect arising from a statutory review. There should be no mistake about our views, however. We opposed the Principal Act in 2013. The scheme established by the Act remains woefully and scandalously inadequate to the needs of victims of crime. The government claims the earlier scheme was unsustainable. In plain English, it did not want to continue the compensation scheme for victims of crime. The government that can splurge on multi-billion-dollar stadia is not prepared to provide compensation to the victims of crime in this state. A clear example of this government's wrong priorities. We remind members that many victims are victims of domestic violence or indeed sexual assault. The government was, of course, shamed into early amendments to the scheme concerning victims of sexual assault. The perversity of the government's action is emphasised by the fact that the gutting of the scheme was driven by the fear of an avalanche of historical claims. The inadequacy of the scheme is starkly revealed when compared with the level of payments that may be made by the National Redress Scheme. Recently, that was the subject of referral legislation in each of the houses of the Parliament. The amendments in this bill are comparatively minor and largely stem from a statutory review. Section 119 of the Principal Act provides that the Minister, in this case the Attorney-General, must review the Act as soon as possible after a period of 3 years after the date of assent of the Act. The Attorney directed that the Department carry out the review on his behalf. Submissions were called for on 3 June and closed on 29 July. The review was tabled in the other place on 6 June, on the same day that the second reading speech was given. We note that that was a review process that was completed with a great deal more expedition than the review, for example, of the Defamation Act, which was recently tabled more than 6 years late. Turning to the provisions of the bill amending the Principal Act, changes are made to Section 36 dealing with recognition payments. Those changes mean that recognition payments are paid to the child under 18 years of age or a homicide victim, regardless of whether they were financially dependent or not. Equally, a recognition payment will be made regardless of whether they were financially dependent to the then spousal partner or the homicide victim. Changes are made to Section 39 in relation to the documentary evidence required to support an application for victim support. That had been directly raised with the Shadow Attorney by Advocacy Services, and the same issues were obviously raised in the review. Whether the changes are sufficient, there must be some doubt, but time will tell. Paragraph 2.8 of the statutory review reads, a significant number of submissions stated that the current documentary requirements are too restrictive and may operate to deter victims attempting to access victim support services. This is because the police or government agencies may not be a victim's preferred point of contact when disclosing violence. Victims of domestic violence, child sexual assault and or physical abuse and sexual assault who may face significant barriers to reporting violence to the police or other authorities are much more likely to attend health services shortly after the violence in order to receive treatment for their injuries. The current requirement may also disproportionately impact disproportionately on marginalised or stigmatised groups such as Aboriginal or LGBTQI victims due to a reluctance to engage with the law enforcement and government agencies, unquote. The amendments here allow reports by an agency that provides support to services to victims of crime to be added to the categories of medical or police report for applications for financial assistance for immediate need or economic loss. Amendments to Section 40 are made to deal with what is described as an unintended drafting anomaly concerning application time limits for family members of homicide victims. Section 43 is amended to give the Commissioner power effectively to apply a slip rule. Section 49, dealing with internal reviews, currently allows a review period of 28 days, which is extended to 90 days by this bill. Section 66 makes a victim a competent, not compellable witness in proceedings in the New South Wales Civil and Administrative Tribunal, NCAT, by a defendant seeking administrative review of a restitution order by the Commissioner for Victims' Rights. Amendments to Section 113 mean that medical reports concerning the victim that are lodged with NCAT or admitted in evidence are not to be disclosed or provided to the defendant, who would be the applicant in those NCAT proceedings. Section 99, dealing with factors to be taken into account by a court in determining whether or not to give a direction for compensation, is amended by deleting the word, quote, condition, unquote, in relation to an aggrieved person. This is an attempt to avoid possible discriminatory impacts. New section 112 capital A makes a sensible amendment concerning the provision of personal information where the victim is under 18 years of age or lacks the capacity to understand the nature of the information. New section 101 makes a minor amendment about the address of an offender being provided to a victim in pursuit of a court-ordered compensation. Given the likelihood of address changes, we are not terribly persuaded of the practical utility of this measure. It's a matter of whether it is going to work in a practical sense, given also that such compensation orders preclude a victim from the victim's compensation scheme. The opposition is unpersuaded, again, of the practical benefit of these provisions in the overwhelming majority of cases. Given the uncertainty of recovery, it is unlikely most victims would seek court orders compensation if it prevented them from the admittedly modest amounts of victims' compensation under the scheme. The final provisions I will mention are those referred to in the statutory review in Part 3 entitled, quote, improving the administration of the VSS, unquote. Paragraph 3.0 states, and I quote, we recommend 3 key amendments to improve the operation of the VSS through ensuring its financial sustainability. In its 2012 review of the old scheme, PricewaterhouseCoopers, brackets PwC, brackets, found the scheme to be financially unsustainable. PwC estimated the contingent liability of the old scheme to be $392 million at June 2012, projected to increase annually by $38 million due to claims, life and the assessed liability of unpaid claims, unquote. The fact that this is a scheme designed for the benefit of accountants and Treasury bureaucrats, it would seem, rather than for victims, it keeps pushing itself on our awareness, Mr Deputy President. This section of the report of the review has 3 elements, each of which is included in the bill before the House. Item 7 of Schedule 1 provides an extra section 41 capital A, which provides that an application for victim support lapses 12 months after its if 12 months has passed since the applicant was first requested to provide evidence to support the application, if the applicant has been requested on 3 separate occasions to provide that evidence and the Commissioner decides that the applicant does not have a valid reason for failing to provide that evidence. The Attorney's second reading speech almost suggests that this is to benefit victims, but the truth is that it's about reducing the contingent liability of the scheme and is driven by financial motivations to write down the outstanding liability. Recommendations 15 and 16 of the statutory review are reflected broadly in item square brackets 11 of Schedule 1. 2 subsections 2 capital A and 2 capital B are added to Section 48 of the Principal Act. 1 makes approval of victim support subject to the condition that a victim must notify the Commissioner of any amount that the person has already received from other sources in connection with the act of violence to which the victim's support relates. The sources here are not defined or restricted in any way. The second reading speech provides the indication, quote, such as insurance claims or other forms of compensation, unquote. That speech also makes the point that the scheme is, quote, a scheme of last resort, unquote. This again gives the impression that government thinking is that the scheme would be much more efficient without victims at all, rather, of course, avoiding the whole purpose of the statute. I acknowledge that interjection. The new Section 2 capital B and Section 48 provides that the Commissioner may withhold payment if the victim fails to comply with Section 2 capital A, dealing with providing advice of amounts received from other sources. The 2013 regulation is amended in various ways to deal with council laws. Section 10 subsection 2 and 11B increase the amounts paid for funerals from $8,000 to $9,500, which simply emphasises the fact that there was no automatic indexation of the amounts specified under the 2013 legislation and may still, even after this indexation, not be adequate. Not only did the government gut the compensation amounts in the old scheme, but in a final twist of the bean counter's knife, they did not index the remaining reduced amounts. In conclusion, I note the provisions of Schedule 3, which make minor amendments to the Crimes Act, the Children's Criminal Proceedings Act and the Crimes, Domestic and Personal Violence Act, which are all entirely supportable. The Civil and Administrative Tribunal Act is also amended And I again note that items 14 and 18 of Schedule 1. We do not oppose the bill, but we have a view that it should be significantly improved. The government that has embarked upon this, the current government's stadium splurge, can and should do a lot better for victims of crime in this state.